Thanks for joining us, everyone. I'm Lance Veeser. The battle over abortion rights in Wisconsin headed into a courtroom in Dane County this past week. District Attorney Josh Kaul filed a lawsuit challenging the state's 1849 law that bans nearly all abortions in Wisconsin. Sheboygan County District Attorney Joel Ermansky is defending the law. He says until the legislature repeals the ban, it should still be enforced, even if it's 174 years old. Ermansky and his attorneys are trying to get Kaul's lawsuit thrown out.
When you're talking about a long-standing type prohibition, the burden on implied repeal is actually even higher for the plaintiff. So I think from that perspective, the burden gets higher.
There you heard Ermansky's attorney arguing instead of an implied repeal of the ban, lawmakers should have to physically vote to repeal it. Here to talk about this legal challenge is Attorney General Josh Kaul. First off, thanks so much for the time here today.
Thanks for having me.
Let's just start with the legal arguments here. Why, in your opinion, should this 1849 abortion ban be ruled unenforceable?
Well, we filed suit 4 days after the Supreme Court overturned Roe versus Wade, and we've made a few different arguments for why this should be overturned. One of the fundamental ones is that there were a series of laws that were passed after Roe was decided that regulate lawful abortion in Wisconsin, and those laws are fundamentally in conflict with the 1849 ban, and it can't be the case that it's both legal and illegal at the same time for certain abortions to be performed. And so usually when that conflict situation exists, the more recently passed statutes are the ones that control.
You mentioned the conflict statute. One of them is the 1985 law, which has to do with abortions are legal up until viability. In your opinion, should that be the law then if you get this overturned, the 1849 abortion ban?
If we win in this case, that we will go back to essentially where we were prior to Roe being overturned. We are arguing that the 1849 ban shouldn't be enforced, and so that would have the effect basically of removing that law. That would leave us where we were before, and that would leave the other regulations for abortion in place.
Okay. So, and then one of the other legal arguments you're making is that the law is essentially so old that it can't be deemed enforceable. Is there any precedent in Wisconsin, though, for that legal argument?
Not in Wisconsin, but there's a legal doctrine that's known as desuetude, where the idea is if there's a law, even if it's been on the books, if it's so rarely enforced that it effectively is not being used, it's not fair all of a sudden to enforce that against somebody. And so here we have a law that, of course, wasn't enforced for about 50 years because there was constitutional protection. But even before then, even when abortion was outlawed, it still was very, very rarely enforced in the United States. And now, all of a sudden, to begin enforcing that law again, we think is inconsistent with principles of notice. The legislature, of course, thought that there was this constitutional protection in place. To now impose this law that hadn't been in effect for a long time, we think is inconsistent with our basic democratic principles.
To have legal standing in this case, you have to prove that you've been harmed legally by this. Now, there have been no prosecutions in the state, so as Attorney General, what is your argument about how you have been harmed, legally speaking?
Yeah, we've raised a few different arguments. One of the key points is that we have certain responsibilities as the state's, I do as the state's top law enforcement officer and chief legal official. That includes advising DAs about what the law is and working with people on cases. There's also a doctrine in state law that when there's a case of certain significance, the Attorney General has standing to bring suit, and this is a case of massive significance to the state. So we think we clearly have standing here, but ultimately the court will rule on that and the other issues.
Sheboygan County DA Joel Ermansky, who's one of the defendants in this case, is making the argument that this should be decided by the legislature and the governor. Why, as Attorney General, do you think it is fitting for you to be involving yourself in deciding ultimately what the statute is here in Wisconsin?
Yeah, there are a couple things. First of all, we have laws that are in conflict here, and doctors and patients need clarity about what the law is. Part of our argument is that the 1849 law isn't in effect, but because both of those laws are on the statute books, we've seen doctors stop providing abortion care. Planned Parenthoods have shut down, for example, and women in Wisconsin have been left in a precarious position. Doctors talk about how they're not sure when this exception applies and when they can act to protect the health of their patients. We need to get back to a place where women in Wisconsin have access to safe and legal abortion and their health is being protected. This lawsuit is one of the ways we can get there.
Should you win the challenge, though, will this ultimately go back to the legislature and the governor to determine what the law really is then moving forward if this 1849 ban is ruled unenforceable?
If our suit is successful, the legislature would be able to pass new legislation regarding abortion. That's the way the system is supposed to work. This law, again, hadn't been in effect for decades, and so the legislature in modern times hasn't acted on this law. But that's the way the process is supposed to work. The legislature, if they have the consent of the voters, will pass legislation, and the governor can sign or veto it. Now, as a practical matter, there's obviously a difference between where the legislature is on this and where the governor is on this. But it's important to note that the legislature could end this lawsuit at any time by simply repealing the 1849 abortion ban or by passing new legislation. But that hasn't happened, and so we are acting to protect the safety and health of women in Wisconsin.
The Republicans in the legislature, though, have said maybe they would alter the 1849 ban. What is your response if they were to do something like that, or the fact that they've talked about it?
Well, they've had almost a year now, and they haven't taken any action to get rid of the 1849 ban. There was a proposal made by the Speaker and a few others recently, but that didn't even get a hearing in the legislature. So, so far we haven't seen any action from the legislature, and it's clear that they want to keep this ban with no exceptions for rape or incest in place. We're going to court to fight back against that, and again, to stand up for the rights of women in Wisconsin and the ability of doctors to provide care without having politicians interfering with them doing their work.
This is ultimately likely headed to the Supreme Court. Do you have any indication now after this first hearing when that might happen?
Well, the next step in this case is for the circuit court judge who heard this argument to issue a ruling on the motion to dismiss. When that happens, depending on the result, I think the case will move quickly through the trial court level. After that, there's a very high probability, nearly a certainty, that the case will be appealed. So I do think it will still be a matter of months before the case moves forward, but I'm hopeful that in the next several months and not longer than that, we will get final resolution on this issue.
Janet Protasewicz will be taking office in August. That'll be a liberal majority at that time on the Supreme Court. Do you have any concerns that this case will maybe be heard before that happens?
We'll see what happens in the circuit court. A lot of it depends on how long it takes the judge to decide on the issues before her. But I'm very confident in the strength of our legal arguments. We've got laws that are in conflict. The law is on our side here, and so regardless of who hears this case ultimately, I feel very strong about, very confident about the likely results in this case.
This has been a big topic for elections. Do you anticipate this all being cleared up by the next election here coming up next year?
I think there's a very good chance we will have resolution in this well before the 2024 elections. But abortion rights is going to remain a critical topic in the state of Wisconsin. When the U.S. Supreme Court overturned Roe, that sent this issue back to the states. And so as we talked about before, what the state legislature does and what the governor does is going to have a direct effect on what access to safe and legal abortion women in Wisconsin have. And I think Wisconsinites have made clear that they want to have that access restored. And so I think hopefully we will see the legislature respond to that and do more to protect access to safe and legal abortion in the future.
Would you try another legal challenge here if this case is dismissed?
When the judge rules in this case, regardless of what her ruling is, we're going to analyze that ruling, and we're going to make a decision based on what that ruling says, where we are in the case, and looking at sort of what we think is the most effective way forward. I'm committed to fighting to protect and to restore now access to safe and legal abortion. What path we take, though, is going to depend on how the case develops.
Attorney General Josh Kaul, thank you so much for the time here this week.
Thanks for having me.